All right, we can get our meeting going. Call to order. I want to welcome everybody. We are the Standing Committee on Economic Development and Environment, and this evening we will be doing our public hearing with regards to Bill 46, the Public Lands Act. And to get things started, I'm going to ask Mr. O'Reilly to lead us in a prayer. So if I can ask everyone to stand.
Thank you, Mr. Chair. If you wish to experience peace, provide peace for another. If you wish to know you are safe, cause another to know that they are safe. If you wish to understand seemingly incomprehensible things, help another to understand. If you wish to heal your own sadness or anger, seek to heal the sadness or anger of another. Dalai Lama.
Thank you, Mr. O'Reilly. I'll also, at this time, for the record, ask members to introduce themselves, and I'll start at my left.
Hello, Kieran Tester, member for Cam Lake. Good evening.
MLA for Hay River North, R.J. Simpson.
Kevin O'Reilly, Frame Lake.
And I'm Corey Van Thyn, MLA for Yellowknife North, and the chair of the Standing Committee. We also have with us this evening from our research department, April Taylor, and from our clerk's office, Mr. Michael Ball. And so, today, the Standing Committee on Economic Development and Environment is holding a public hearing on Bill 46, the Public Lands Act. The Standing Committee on Economic Development and Environment is a committee of regular members of the Legislative Assembly. The bill we are reviewing today was introduced by the Minister, given first and second reading in the Legislative Assembly, and then referred to this Standing Committee for review. Legislation is typically brought forward by Cabinet and is reviewed by Standing Committee. The members of this committee are responsible for holding the government to account, and one of the ways we do this is by making sure that proposed laws are supported by the people of the Northwest Territories. It is our responsibility to consult with residents on what they like or don't like about the bill. We would like to hear your views and comments, which will be used by the committee to identify any changes we would like to see made to the draft legislation, and which will then report back to our colleagues in the Assembly. The Standing Committee is holding public hearings on this bill we've been in already Fort Smith, Katloditchi, Hay River, yesterday in Fort Simpson. Today at noon we are in Fort Providence, and we're here this evening in Yellowknife, and we head off to Inuvik tomorrow. We will then report back to the Legislative Assembly on the proposed legislation during the upcoming August sitting of the Legislative Assembly. So I wish to briefly describe the intent of this bill. Bill 46, the Public Lands Act, proposes to establish new legislation that will repeal and replace the Commissioner's Land Act, which governs the administration of small amounts of land in and around some NWT communities, and the Northwest Territories Lands Act, the post-devolution mirrored legislation, replacing the Federal Territorial Lands Act used to administer the majority of public lands in the NWT. It will establish mechanisms to allocate land through grants, sales, leases, licenses, permits, and other instruments. It will establish authorities for public land administration and control, including controls and protections for the sale, occupancy, and use of land, using a range of tools such as land withdrawals, reservations, securities, inspections, and enforcement. And it sets out regulation-making authority specific to land administration matters, such as collecting rents and royalties, recording and maintaining records, and land transactions like recreational leases or quarrying materials. For those who haven't already helped themselves, we have copies of the bill, some plain language material, and I believe what we heard report are on the side table, and we encourage you to help yourself there. If you'd like to share your views with us this evening, I believe we have a bit of a list going, and so far I have on the list Emery, Karen, and Mark. Is Mark?
No, I'm not actually presenting.
Oh, okay, so Karen and Emery, and if there's anyone else, I will just ask at the time, and you can. We don't have a packed house here this evening, so I'm sure we'll have enough time for everybody to present. Also, if you haven't already, and if you care to, we accept written submissions, and we'll be doing that up until July 5th at 5 p.m. So even after this evening, if you have additional thoughts that you care to share, and we encourage that, we will receive those up until July 5th at 5 p.m., and our clerk, Michael Ball, can give you his email so that you can send those in. One final piece of housekeeping. Please remember that all submissions will be part of official committee records and may be reflected in our final report. Any submissions made during this meeting may also be televised or broadcast via social media, and I don't believe we're doing that this evening, or are we? Oh, we are being broadcast. Okay, that's excellent. And of course, the proceedings are being recorded. And so thank you, everyone, for your patience in allowing this introduction. And with members' agreement, we can now open the floor to comments from the public. Do members agree? All right. Thank you. So first on my list, I have Emery Paquin. Come on up. Emery, and just for the witnesses that are coming up to the witness table, our awesome audio-visual technician will manage the microphone, so really the conversation just exchanges through me as the chair, and he will manage the mics for you. And so I see you have a presentation.
Yes, we do.
And just can I know who is going to be doing the presentation? Is it yourself, Emery?
I'll be making the presentation.
Okay. And when you need the PowerPoint switch, just let us know and we can switch to the next page. All right. So without further ado, Emery, I turn it over to you to introduce yourself and your organization, and you can lead us through the presentation.
Okay.
Thank you.
Thank you, Mr. Chair. On behalf of the Independent Environmental Monitoring Agency, we would like to thank the Standing Committee for the opportunity to make a presentation this evening with respect to Bill 46. In the way of introduction, the Monitoring Agency is a non-profit organization that was created in 1997 under an environmental agreement signed between BHP Diamonds and the governments of Canada and the Northwest Territories. Our mandate is to serve as a public watchdog over the Ekati project by, amongst other things, providing advice to both the owner and the regulators of the Ekati project, and to maximize the effectiveness and coordination of environmental monitoring and regulation for the project. The topic we'd like to discuss with you this evening is that of land and water-related financial security associated with abandonment and reclamation. Our overall objective in this regard is to ensure the resource development projects are appropriately secured against all reasonable closure and reclamation liabilities, and that the regulatory process continues to be effective and efficient. While the specific issue that has prompted the agency to appear this evening is associated with the Ekati mine, the subject applies to all industrial development projects permitted and licensed through the Mackenzie Valley Land Use Regulations and the Waters Regulations. While researching this subject, we noted that these objectives are consistent with the priorities that were developed by all members of the 18th Legislative Assembly in 2015, and later revised in 2017 at the midpoint of your terms. The specific priority we point to is the third priority under the general heading, Economy, Environment, and Climate Change. That priority reads, in part, improving coordination and effectiveness in resource management systems, recognizing traditional knowledge, land claims agreements, and devolution. It is our opinion that protecting the public interest by holding adequate financial security against any reasonable land and water-related closure and reclamation liabilities and reducing the administration and financial burden on industry and on government is consistent with your own priority and is in the best interest of all residents. As you are aware, authority for setting security currently rests with the Gwich'in, Sahtu, Wekwizi, and the Mackenzie Valley Land and Water Boards in the Mackenzie Valley, and the Inuvialuit Water Board in the Inuvialuit Settlement Region. The boards are assisted by the guidelines for the closure and reclamation of advanced mineral exploration and mine sites in the NWT. These guidelines ensure a predictable, consistent, and efficient process is followed. Under these guidelines, every new and existing mineral exploration and mining development must be able to support the cost of closure and reclamation and be able to provide adequate security to ensure the operator, rather than public government, bears the cost of closure and reclamation. Next slide, Michael. The Mackenzie Valley Land Use Regulations and water regulations provide management boards with the authority to set the financial security through land use permits and water licenses. More specifically, for land, Section 32(1) of the Mackenzie Valley Land Use Regulations states the board may require security in an amount not exceeding the aggregate costs for the abandonment of the land use operation. And I emphasize the words, the land use operation. For water, subsection 11 sub 1 of the waters regulations provides similar authority except that the security may not exceed the costs of abandonment and restoration of the undertaking. And again, I emphasize the words of the undertaking. In the case of the Acadie project, in a recent ruling dated May 9th, 2019, the Wekwizi Land and Water Board confirmed the term undertaking to include the whole of the Acadie project, including all the area affected by the land use permit and the water license. And this ruling is consistent with past practices. So, in other words, when we're talking about security set under a land use permit, we're only talking about the land-related securities. But the securities that are required and established under a water license can apply to both land and water liabilities. That's the point I'm trying to make. Next slide, please. As I just mentioned, the financial securities are assigned by the Land and Water Management Boards. Except in the case of the Inuvialuit Settlement Region, land and water-related securities are each decided by the same board. In all cases, the security, whether it's in the form of a promissory note, a certified check, irrevocable letter of credit, or cash, is held by the ministers of the government of the Northwest Territories. Security assigned under the land use permit is held by the Minister of Lands, and security under the water license is held by the minister responsible for ENR. There are, however, no legislated or regulatory requirements that we could find that determine how security should or must be allocated between land and water. The MVRMA and the Waters Act leave the discretion solely in the hands of the issuing board. In cases where a board has had applications for both a land use permit and a water license, past practices and decisions for the allocation of security have varied based on the record before the board. The establishment of a reasonably accurate security and its allocation between land and water is not an exact science. as boards and regulators are essentially attempting to estimate future costs and liabilities. To assist, a computer model known as the reclaim model is used to help parties take into account the multiple components of closure and reclamation. There are a few key considerations that I'd like to bring to your attention with respect to the reclaim model. First, the estimate that's arrived through the model is assumed to cover all the closure and reclamation costs, including land and water costs, which would be assumed by the landowner should the company become insolvent. Second, the direct costs associated with the mine components, for example, open pits, tailings, impoundment areas, are estimated separately. The costs are based on unit costs. So, as an example, if the cost of providing, transporting, and placing rock used to cover a tailings pond is $50 per ton, and there's 100,000 tons of rock required, then the estimated cost to cover the impoundment area is $5 million. It's simply a matter of math. And finally, and this is most important, the user of reclaim can assign a percentage of each cost to be included as either land-related or water-related. So using the tailings impoundment area as an example, placing a waste rock could be assigned 50% land liability, 50% water liability. In another case, it could be assigned 25-75. Okay? There is no exact science or guidance that I'm aware of to this assignment. Next. So there are many challenges in setting, assigning, and administering financial security. Some of these include the fact that the reclaim model does not segregate land and water-related costs and liabilities well. Instead, it relies on the user of the model to assign a percentage to each category. There are many examples of inconsistencies in board allocation of securities. Sometimes, as in the recent ruling by the Wheezy Board related to the Acadie's Misery Underground project, both land and water-related securities were established through the water license. In contrast, the same board earlier assigned land and water-related securities separately for the J Project Early Works and the Pigeon Project taking place at Acadie. So there is inconsistencies. When progressive or early reclamation is undertaken, the company is entitled to a full or partial return of security. In the case of security established through a water license, relinquishment can be granted by the board without the need for a formal public process. However, where the land-related security is established under a land use permit, a formal and lengthy public process is required, as the permit must be amended in accordance with the regulations. This longer, more complicated process dealing with land-related securities can act as a disincentive rather than an incentive for the developer to undertake progressive reclamation. Separating land and water liabilities adds additional costs and administrative burden to industry. Cost and administrative burden is also added to government, as two separate accounts must be maintained if the liabilities are separated into land and water. In addition, where land-related security is held by the Minister of Lands and water-related security is held by the Minister of E&R, conflict may arise in cases of company insolvency as to whether the original allocation of liabilities accurately reflect the separate monetary costs of reclamation. And the final challenge we've identified is, if there were to be any amendments to the MVRMA or to the regulations under that act, to adjust the Minister of Land's authorities as relate to administering land-related security. This would require actions by the Parliament of Canada. Next slide, please. So why are we appearing before you today? We believe Bill 46, the Public Land Act, provides an opportunity to resolve these challenges and advance closure and reclamation planning and actions in the NWT. Section 8 of the bill proposes to authorize the minister, presumably the Minister of Lands, to require the posting of land-related security, relinquishment and return the security to the company where the land has been restored, and use the security to restore the land when the company fails to do so. However, in its current form, Section 8 is silent on which minister is responsible for holding the security. The monitoring agency believes that through this silence, the section implicitly directs the minister responsible for lands to hold the security, thereby perpetuating the challenges described earlier. As a solution, the agency is suggesting that a new clause be added to Section 8. The clause would include authority to enable land-related securities to be held, together with water-related securities, by the minister responsible for water in the same account. This addition would not alter the obligations or authorities of the minister responsible for lands as they currently relate to administering land-related security. But it would increase the consistency, predictability, and efficiency of how security is established, provided, held, and utilized. We note that a consequential amendment to the Waters Act or regulation may also be required. So finally, the monitoring agency believes an opportunity exists through Bill 46 to improve the way closure and reclamation financial security is established, provided, held, and utilized. An amendment, as we described, would not result in a change to the total security held by the GNWT. It would help to ensure process consistency, predictability, and efficiency. It would promote progressive or early reclamation activities by the developer. It would reduce cost and administrative burden on industry, and it would reduce cost, administrative burden, and potential conflicts within and between the departments of Lands and ENR. So that concludes our presentation, and we'd be happy to take any questions you may have.
All right. Thank you very much, Emery. We really appreciate your submission this evening. I'll turn it over to committee. Comments, questions from committee for the presenter? Mr. O'Reilly.
Thanks, Mr. Chair, and thanks to our two guests this evening. I'm just wondering if you can provide a little bit more background or context to the situation that arose where I guess, as I understand it, the Waikiki Land and Water Board identified a security amount for Misery expansion, and it wasn't split between land and water, and GNWT doesn't want to accept part of the security. Is that what's happening here? Thanks, Mr. Chair.
Thank you. Mr. Paquin?
Thank you, Mr. Chair. That's correct. This is the most recent issue, and this is, for the purposes of timing, I think it really facilitated our presence here this evening. Yes, about a year ago, Dominion Diamonds proposed to begin underground mining at their Misery Pipe at Acadie. So the Wekweezi Land and Water Board held a public hearing, a process to amend the water license. And through that process, the additional security for the MUG, or Misery Underground project, was assigned under the water license. When Dominion went to pay the financial security, the Minister of E&R refused to accept that security, saying that the department did not have the authority to hold land-related security. This took us as a bit of a surprise, because this has been normal practice, certainly post-devolution up until this decision was made by the department just recently. So the current situation at Acadie is that Dominion has proceeded to develop the underground operation at Misery. The security has not been paid to the GNWT, despite Dominion's efforts to do so. So essentially, the project is unsecured with respect to closure and reclamation. Now, I would say that this is the most recent example, but there are other examples where there has been difficulties associated with the splitting out of land and water-related liabilities, but certainly the MUG project is the most recent one.
Right. Thank you. Further questions, Mr. O'Reilly?
Thanks, Mr. Chair. Can you tell me what the additional security amount for Misery Underground was calculated as by the Wekweezi Land and Water Board? Thanks, Mr. Chair.
Thank you. Mr. Paquin?
Thank you, Mr. Chair. The amount of security is quite small, about $1.5 million. But when you look at that, you have to also look at it with respect to the overall amount of security that the company has with the government for the project, which is substantially more than that. So it's in this case, it's not that project, the Acadie project, is significantly undersecured because of this. It is the process and the inefficiencies and the difficulties it may lend to other projects in the future that we bring this to your attention.
Thank you. Anything further, Mr. O'Reilly?
Yes, Mr. Chair, thank you. Yeah, I get it. So it's $1.5 million, and I think it's like in the order of $200 million or something that okay, thank you, even more than that in terms of the total security held for the project. And it has a relatively large footprint. I think it's about the size of the city of Yellowknife now, so the built-up area of the size of the city of Yellowknife. But so it's the precedent-setting nature of this recent decision in that E&R refuses to accept the security and the company's gone ahead. Are you aware of Lands or E&R putting forward any proposals or ideas to resolve this situation? Thanks, Mr. Chair.
Thank you. Mr. Paquin?
We are aware that Dominion put forward a request for ruling, and this is a legal process that in this case the Wekweezi Land and Water Board goes through. The ruling by the board just came out, and that ruling essentially said that the board has the authority under the Waters Act to establish both land and water related securities under the water license. They didn't explicitly state that they were going to continue to do so, but they explicitly stated that they have the authority to do so. At this point, I don't know. Mark, have you received any update on ENR's response to that ruling?
Thank you. Mr., it's pronounced Casas? Casas?
Thanks. Yeah, Emery. That was the last correspondence they had, was the decision. So there was a request for ruling, came in I think it was November, and there was a bunch of IRs back and forth, and the GNWT clearly stated their position that according to them, they need it separated into land and water, and both ministers are responsible for those two. And then which was the question, and then the Land and Water, Bukisi Land and Water Board took that information and came out with the understanding and statement that they are still able to set it under the water, and they did not change their decision, so they still maintain that it can be held underwater, but on the record, clearly the GNWT feels that they can only accept it under the two ministers, so that's why we're sort of in an impasse right now.
All right. Thank you. Further, Mr. O'Reilly.
Thanks, Mr. Chair. No, that's helpful background, and we may do some of our own digging around on that. I just wanted to mention that I was glad that you referred to the mandate of the 18th Assembly in terms of, improving resource management and so on. There's another part of the mandate, and I'm just going to read this out for you. Develop an integrated, I'll just say, develop a sound financial security system to prevent public liabilities. It sounds like there's a problem here. And we now have a relatively small project where GNWT has refused to accept security that's been calculated by the Land and Water Board. So I think there's a problem here, and you've offered some suggestions on how it might start to be addressed under this bill, but are there other issues, or is this the best solution, or is there other things that you might suggest to help resolve the situation? Thanks, Mr. Chair.
Thank you. Mr. Paquin?
Thank you, Mr. Chair. This may not be the only solution, Mr. O'Reilly. It is, we believe, a solution, and a relatively simple solution. One of the complicating factors here is the MVRMA. And the regulations under the MVRMA, the land use regulations under the MVRMA clearly state that the minister responsible for lands has the authority to establish land-related or security related to land-related liabilities. So the solution that we're presenting here wouldn't change the overall authority of the Minister of Lands. The minister would still be able to exercise those authorities in accordance with the federal regulations. The only change would be, instead of the land and water-related liabilities being held in two accounts, be held in one account.
Anything further, Mr. O'Reilly?
No, I just want to thank our witnesses for bringing forward the presentation and this information on what seems to be a recent development and how GNWT manages financial security. Thanks, Mr. Chair.
Thank you. Next, I have Mr. Testart.
Thank you, Mr. Chair, and thank you very much to the witnesses. I was wondering about this section. We've taken a look at it, but it's nice to have your comments on this. We haven't heard too much around the securities issue so far on our tour, and it's nice to have your expertise brought to bear to the committee's benefit. You mentioned that this recent decision with the minister kind of not accepting the security, that came as a surprise, and in past practice that hasn't been an issue. Can you just confirm that before this instance, the GNWT was accepting securities, whether or not they were land, water, this issue did not seem to appear. Thank you.
Thank you. Mr. Paquin?
Mr. Chair, this is the first time that I have become aware of this issue. The GNWT has, to my knowledge, always accepted the securities in the amounts that the Water Board has set through either the land use permit or the water license. And as I mentioned during my presentation, very often the water license does establish securities for both land and water-related liabilities. But this is the first time that I know of that when the company has gone to provide the security, the Minister of ENR, it's not, I think we have to be careful here. We're not talking about the GNWT, we're talking, the Minister of ENR, the Department of ENR in this case, refused to accept that security. But no, this is the first time that I've heard of it.
Thank you. Further, Mr. Testart?
Thank you, Mr. Chair, and thank you for that clarification. And you're confident that the recommended amendments you've proposed would allow the Minister of ENR in this case, amongst the other changes you made, but would resolve this issue, this particular issue, and create that certainty and ease of regulatory burden that you think is going to help move things forward. Thank you.
Thank you. Mr. Paquin?
Thank you, Mr. Chair. Based upon the responses that ENR provided to the Wigweezy Land and Water Board through the request for ruling process, yes, it was very clear to me that the issue was ENR no longer feels they have the authority to hold land-related securities. So if this bill or this act provided the Minister of Lands with the authority to transfer or allow that security to be held by another minister, yes, I believe the issue would be resolved, and I think it's very doable under Section 8. But I would suggest a member of the Legislation Division would need to work out the exact wording. We're not prepared to provide recommended wording.
Right. Thank you. Further, Mr. Testart?
Thank you. And we have experts for that, so the suggestion's well enough. So on the topic of progressive reclamation, you also said these kind of changes would help incentivize progressive reclamation. I don't know if you have this information available right now, but are you aware of other regulatory regimes that work better, that have incentives built in or facilitate progressive reclamation more often than what we're currently dealing with in the Northwest Territories? And could you point us to those examples? Thank you.
Thank you. Mr. Paquin?
Thank you, Mr. Chair. I don't have specific examples from other jurisdictions, but maybe if I explain what happens in our own jurisdiction a little bit more clear, that might help. When a security is established under a water license, it is held. There's a schedule attached to the water license that identifies the amount of security that needs to be submitted. Okay. When a company, I'll use Dominion because that's what I'm most familiar with. When Dominion completes security, when Dominion completes progressive reclamation, they then apply to the Land and Water Board for a relinquishment or return of all or a portion of the security that was assigned to that specific project. The board itself can amend the schedule. Okay. However, when a security is assigned under a land use permit, it's not it's a term and condition of the permit itself. And so if a company wishes to complete progressive reclamation and request relinquishment of a portion of that security, the permit itself has to be amended. And that's a formal process. The company has to request an amendment, apply for an amendment. The board then has to conduct internal consultations and public hearings, and the act itself sets out the process. So it's much more cumbersome and difficult and time-consuming than simply the board amending the schedule to the water license.
Thank you. Anything further, Mr. Testart?
Thank you for that clarification. That's helpful. I mean, we don't need more than that, I think. And I'm always interested in how we can, my priority is responsible resource development, and if we can find an easier way to get securities where they belong and encourage companies to be proactive when it comes to their environmental liabilities, I think that's a win-win. So I'm very interested in pursuing your suggestions, and thank you very much for providing them tonight. Thank you.
Thank you. Anything further from committee? If there's nothing further, I want to, Mr. Simpson.
Sorry, and I'm sorry if this has been addressed. I was reading something here, but you stated that ENR refused to accept a security from Dominion because it was related to land. And you said traditionally that's been the practice. So are you aware if ENR was holding land-related securities that they then returned after this decision, or did they keep holding on to those? Thank you.
Thank you. Mr. Paquin?
I don't quite understand. Can you
For
Can you
clarification,
rephrase?
Mr. Simpson.
Sure. So ENR refused to take a security because it was related to land. Traditionally, you said that they would accept those. After they decided they were not going to accept security from Dominion, were they in possession of other securities related to lands that they then returned?
Thank you. Mr. Paquin?
Okay. Thank you, Mr. Chair. The decision by ENR not to accept the land-related securities associated with the Misery Underground project is very recent. Within the last couple of months, two months. There has been no request for return of any security within that time period. Prior to that period, prior to the Misery Underground project decision by ENR, there was security, both land and water, returned to the company from ENR for security that was held under the water license. Does that?
Right. Thank you. Mr. Simpson?
Thank you, and I appreciate that. And I'm just wondering, outside of that particular project, other, securities that were held by posted by other companies throughout the territory for other projects. I guess my question was about those, but I know that you're not ENR, so that's not something that we can get. I was just wondering if that was something that you had heard of, but I didn't realize it was so recent. Thank you.
If there's nothing further from committee, I want to thank you again for presenting. If there's an opportunity to maybe get your speaking notes from your presentation, we would really appreciate that. That helps our research team. And we have a copy of the presentation, but sometimes you have speaking notes with it that helps. So we would appreciate getting a copy of those. And then if you're going to provide any other written submission, I just remind you that before July 5th at 5 p.m. would be fantastic. Mr. Paquin?
Just a question for clarification, Mr. Chair. Would you like to have these speaking points on paper, or would you prefer them electronically?
Electronically is probably better.
All right, we will provide those to Mr. Ball
right.
tomorrow.
Okay, that's fantastic. Much appreciated. Thanks again. All right. Next, we have Karen Hamry, And Karen is presenting on behalf of a group of NGOs, Alternatives North, Ecology North, Canadian Arctic Resources Committee, Council of Canadians NWT Chapter, and Canadian Parks and Wilderness Society NWT Chapter. Does that belong to one of them? Oh, you might want. All right, and Ms. Hamray, I turn it over to you to record your name for the record, and you can present.
Okay.
Over to you.
Thank you for the opportunity to present. My name is Karen Hamry, and as the chair stated, I am doing this submission on behalf of Alternatives North, Ecology North, Canadian Arctic Resources Committee, Council of Canadians, the NWT Chapter, Canadian Parks and Wilderness Society, NWT Chapter. And those groups have a variety of social, economic, and environmental mandates, and so joined together for the written submission, which was sent to you yesterday, and this presentation. So we understand from the background materials that this initiative was intended only to address current near-term operational needs and issues rather than a larger scope review. But even without a large scope review, we do believe this bill should address some of the things that were stated in the plain language materials. And one was advance the post-devolution vision for an integrated land and resource management regime. And given this Assembly's stated commitment to accountability and transparency, the Act does need to ensure public engagement and the ability to respond to the real risks to our fragile northern ecosystems. So we've stated in our written submission that we believe there are a number of positive aspects to the bill, but I'll just go into some of the changes that we were looking for, because we do think that there are changes needed to meet that test of integrated land and resource management, public engagement, and regard for the environment now and for future generations. So I will touch on each of the key recommendations we have in the paper. I won't go through the wording, the suggested wording, just an overview of them. And to start with is the purpose. We believe it's very important to include a purpose statement in the Act, especially as this brings together two acts and has multiple purposes. And for the GNWT to really be guided by the land use and sustainability framework that the Assembly worked a lot on, a purpose would bring those concepts and principles into the legislation. So we have given it some suggested wording, but the point there that I'd like to make is the purpose brings in the concept that within the context of Indigenous rights, it's the GNWT that holds public land in trust, and the true owner of the land is the public, and that's sort of the basis of the Act. And we need to manage the lands and waters to provide environmental, economic, social, and cultural benefits to all NWT residents now and in the future. So again, those benefits are not just to ourselves, but to future generations. The purpose would also acknowledge that the lands are used for multiple purposes and multiple reasons. So it's recreation, agriculture, forestry, mineral development, spiritual needs, all those things, as well as the services that the land provides to us in terms of ecological services. And we do believe that a purpose is necessary to acknowledge land, resource, and self-government agreements and the respect for Aboriginal and treaty rights of Indigenous people. So having those concepts stated in a purpose would really make the act clear to legislators as well as to residents. And for further clarity, we are suggesting the inclusion of some principles into the act, and we recommended inserting 5 principles: precautionary, polluter pay, ecological sustainability, intergenerational equity, and environmental justice. And the wording is there. I heard that you said you accept some further written submissions. We had some discussion with Professor Linda Collins about how we worded number 3, which is the one on ecological sustainability. So we will revise the wording slightly when we get you our revised submission. And on the matter of security, so that was very good to hear a presentation about that. Of course, that's a huge issue for residents and for the GNWT. In our reading, it's very concerning that we see that issue is shown as discretionary, given that the Commissioners' Land Act posting of security was mandatory. This is a step backwards in this act as it's proposed. So we are suggesting the word shall in this, along with some suggestions for the direction of developing the regulations around security. So, for instance, we have a lot of issues with government and taxpayer liability, and so really the legislation needs to direct the development of those regulations more. So, for instance, that the security must be liquid and irrevocable. I think we'll probably take the comments of the monitoring agency into account when we do our next submission as well. Another issue is the lack of requirement for notice to the public about grants and dispositions. And there needs to be something about notice to Indigenous organizations, to community governments, to the various co-management bodies, and of course to the public in general. And along with notice, the public and the groups need to be given a chance to comment on grants and dispositions. So, for example, there should be engagement with community governments before land is given for disposition within their community boundaries. To help with all of this, we included a recommendation for a public registry. And a public registry would take the Lands Department mapping site, which they call Atlas, one step further. It would, we suggest, include additional information that is on that Atlas site. So, for instance, information about security requirements, about contraventions to the Act, and penalties under the Act. Another matter has to do with land and water and that thing that's in between called wetlands. We have to be really careful about how we treat our wetlands, that we don't lose them for many, many reasons. And sort of a typical practice in the past has been treating them as a place to put extra fill so that you could turn it into land. And what we're saying is that the wording should include wetlands in the areas that are retained under the control of the Commissioner. So, in essence, that would be treating wetlands like water instead of like land. And then on to the concern about granular resources. Obviously, we need granular resources in the development of our communities, in our industrial development, roads, utilities, all sorts of things. And how that's to be managed is left to the regulations. And given the importance of appropriately managing our granular resources and their importance across so many sectors, we think that there needs to be some wording in the legislation to help guide the development of those regulations. So, for instance, there needs to be a requirement stated in the legislation for a development plan for any pit or quarry. And that can be then further developed in the regulations, but we need to make sure that the stages of use and cleanup are quite clear. We noted, so all of those points, we've made some suggestions for wording, and of course that's up to the legislators and legal people to, figure out the exact wording. But we also had concerns that we didn't have any suggestions on for wording, but hope that Sketty can take those into account when you're reviewing the bill. So, for instance, it isn't clear how the Act encourages land to be used for gardens, agriculture, and similar matters. And there may be some wording that you could add. It also is not clear why there aren't any limits placed on leases in the Act. So the previous Act had 640 acres, and this was supposed to sort of be more of an administrative update, so that could have just been changed to metric, but it wasn't, and we couldn't find any explanation of why that was completely deleted from the Act, from the bill. And I've talked a bit about regulations and a lot being left to regulations, made some suggestions for how this bill could direct those regulations. And we realize that Sketty doesn't have responsibility for regulations, but would like it on the record that we, the signing organizations, would like to be involved in the development of the regulations for this Act. And again, our understanding was that this was intended more as a near-term operational type review, and that there's supposed to be a larger scope review. So to us, that would indicate not just looking at the regulations, but at the Act itself. And so when that larger scope review happens, again, we would just like it on the record that we would like to be notified so that we could be involved in that. And thank you very much, and I welcome questions.
All right, thank you very much, Ms. Hamry, for your presentation. We also have your previous written submission, and we look forward to getting any updates on that submission before July 5th. I'll turn it over to committee. Comments, questions from committee? Mr. Testart?
More of a comment. Thank you, Mr. Chair, and thank you very much for presenting. The issues you've proposed around the purpose and the purpose statement, and this is difficult for our committee to address within the rules for amendment for bills. And essentially, we'll have to look in to see what we can do, but we've also heard submissions earlier this week on adding a preamble, like we've seen with the MRA and the, or not the MRA, the Protected Areas Act, or purpose statement. But the way the rules of amendment work, you can't kind of add that stuff after the bill's already been accepted by the House. So we'll have to look into that and see if we can fine tune it, but I want to make sure our understanding of expectations is very clear, that sometimes we get these submissions and there's only so much we can do. But I think you raise a very valid point that there ought to be a very clear understanding in the public's eye of what this bill is supposed to do. I think a number of your suggestions are similar to other ones we've heard about improving transparency and notification, especially vis-a-vis Indigenous governments whose constitutional rights to use and possess the land have to be respected, and the bill only really addresses that at the beginning and not substantively in the detail. So and you've given us a lot to think about here, so I just thank you for your submission. I wanted to clarify that one point that's probably a concern. But I think this is a good place to start on improving some of the ability for the public to see what's going on with these dispositions of land. And one thing we've learned from our tour is that land is life in more ways than one, and the lack of clarity around land in both the regulations and how it's been managed in the past have created a patchwork of public policy that is really impacting the lives of people in a meaningful way, and we have to find a very clear set of rules that everyone can understand, everyone can access, and that provides both certainty and relief for people who've been struggling with this issue of land for a very long time. So thank you again. This is an important bill, and your contributions to are an important part of our democratic process. Thank you.
Thank you, Mr. Testart. Further comments, questions from committee? Mr. O'Reilly?
Thanks, Mr. Chair. Maybe I'll start with one of our committee members has said that the NGOs are really from outside of the Northwest Territories, that they've asked for, and I'll leave it at that, but can you just tell us a little bit more about the 5 organizations that have signed on to this submission? Thanks, Mr. Chair.
Thank you. Ms. Hamry?
Alternatives North is a solely volunteer-run organization with environmental, social, and economic justice mandate, and all of the members are Northwest Territories. Ecology North, I think, was started by Barb Bromley, I believe. And so is obviously a very long-standing, important local northern group. Canadian Arctic Resources Committee is clearly a Canadian organization, but has done an awful lot of work in the Northwest Territories. And in fact, Kevin O'Reilly used to be an employee of CARC when he, in a previous life, but when he lived here in Yellowknife. So, and I know, I don't keep up with that organization, but I know at least 3 board members are from the Northwest Territories. So, and Council of Canadians, NWT chapter, as the name suggests, is a Canadian organization, but it does have an NWT chapter, and that's a very important part of having these national organizations, is to have a representative chapter here in the NWT, and they do a lot of particularly focus on water issues, and so you are clearly interested in this act and how that relates to the Waters Act. Canadian Parks and Wilderness Society, NWT chapter, again, it's a Canadian organization. And True Confessions, I was one of the founding members of the NWT chapter, and that was over 20 years ago. And again, I think it's very important for Canadian organizations to have the perspective of the North when they're doing work across the country. And as one of the founding members, I'd have to say I'm quite proud that the organization has done that. And yes, so I find it disappointing that information is out there that these organizations are not, well, not only are they not Northern, but they might not even be Canadian. It's just, there is no basis in that. And I can very, very positively state that. So,
I think for any members that have been here for any length of time, can certainly appreciate that these organizations have been in and around various circles for a lengthy period of time. So, further, Mr. O'Reilly.
Yeah, thanks, Mr. Chair, and thanks for helping to clarify that for us and getting it on the record. You've proposed a number of ideas here for a purpose statement, and I'm just wondering whether how you prepared these, or did you draw upon any other documents? I noticed earlier in the written submission that you referred to the land use sustainability framework, but the ones that you've suggested here, are they drawn from any particular set of documents, or are these just ideas that, and look, I think they're great, I think they're very helpful, but I just wonder how you prepared them and what you drew from to put together the list. Thanks, Mr. Chair.
Thank you. Ms. Hamry?
Well, as the committee's quite aware, there's been a bunch of legislation that's come forward, and I've been involved in reviewing several of those bills, and so some of these purpose statements have been drawn from the purpose statements of other acts, and yes, some. There's no wording that's directly in those from the land use sustainability framework, but taking those ideas and the principles in that and trying to put those into the purpose statement, and things like regulate in a transparent manner, that look back at what the mandate of the Assembly is and try to put some of that wording in. So that's how it was developed.
All right. Thank you. Anything further, Mr. O'Reilly?
Thanks, Mr. Chair. I think you've talked about this in general terms and in some parts of the submission, but can you just sort of maybe just capture for us what the expectation of NGOs was in terms of having participated in the stakeholder advisory group and some of those meetings, and having reviewed, the discussion papers and so on, and then you compare that with what we ended up with, a bill. If you could just highlight for us whether that made any sense and whether there was any surprises in that process and so on. Thanks, Mr. Chair.
Thank you. Ms. Hamry?
So none of the 5 organizations were involved in stakeholder meetings for this bill. For the other bills, we were involved in the stakeholder meetings. The plain language material for this bill was particularly confusing because it was done for 2 separate bills, and then it became one. And we do think that it's a strength, that it's a single act rather than having 2 separate acts. As Karen Testart mentioned, there's this patchwork, and having it as a single act we see as a positive thing to help reduce that patchwork. But when your plain language material talks about 2 acts and then you're trying to review that as 1 act, it makes it very difficult.
All right. Thank you. Anything further, Mr. O'Reilly?
Thanks, Mr. Chair. I just want to thank Ms. Henry. I think there's lots of interesting ideas and some specific comments, suggestions in here, and I think it's very helpful. It's probably one of the more detailed submissions we've received on the bill, so thank you very much.
Right. Thank you again, and we look forward to seeing the submission. Are there any further people who would like to speak or comment on Bill 46, Public Lands Act? If there's nobody further, Mr. Testart, you have a comment?
Yes, I just want to say, for the benefit of our audience, in the other communities we visit, we haven't always talked about the technical elements of the bill. A lot of the discussion has been around the personal experience people have with land management in the Northwest Territory. So if they have problems with their leases or taxation of property, I mean, that's not really part of this bill, but we have heard a lot of that. So I just wanted to say, if anyone here has those kind of experiences or would like to speak about those experiences, I think because we've heard those before, it's fair game tonight. Thank you, Mr. Chair.
I'm aware of who you're pointing that toward, as they are constituents, and I already tried to go down that road, but they will. They're here for information's sake more so, I think, this evening, and will probably reach out to me personally at a later date. But if there are no other presenters or anyone speaking this evening, then does committee agree that this concludes this portion of our proceedings? Agreed. Thank you. And with that, we thank you all once again for coming out and sharing your comments and your presentations. We can be adjourned. Thank you.